In today's lecture, we're going to be looking at the structure and history of state courts in the United States. Um, the development of state courts has really progressed with the need for them. Early colonial courts looked much like the courts of England, where the people that settled the colonies on the East Coast came from. There were justices that moved around if the area needed that. If the area had enough cases, they would have a permanent judicial fixture in that area. And then as the country expanded, much the same way that our policing systems did, and then the correctional systems that followed the development of the policing system and the court system. The court systems just developed as there was a need for them. Again, different policies for different areas. A lot of mobile justices early, especially in areas that had a very sparse population density. And then as major cities were formed, there was a need for a permanent judicial fixture, and the system evolved to meet the need. A lot of the modernization, some of that we'll talk about later, has been aimed at trying to make the process more efficient, having to have people wait less time from being charged with an offense to having their trial, their proverbial day in court. The lowest level of state judicial systems or local judicial systems are the trial courts of limited jurisdiction. Typically, the most common one is traffic court, municipal court, handling very minor cases, non-felony criminal cases, a lot of traffic offenses, potentially some small claims civil cases, depending on the need in that area. Also, they can sometimes be the ones that are signing search warrants and also handling early trial phases. Some of the more formal processes that have to be gone through before the court is actually assigned a permanent judge for a particular criminal case, especially a high-profile felony case. So these courts do a lot of different tasks. Basically, all the minor jobs that the other courts are, because of the frequency and numerous nature of these tasks, the municipal courts of limited jurisdiction are assigned to cover. The higher courts are ill-equipped to handle them, just based on their manpower that they have in those facilities. There is another type of sort of like a bottom of the rung type of judicial system in some rural areas. Again, as the judicial systems evolved to suit the needs of particular areas, some areas didn't require a very elaborate judicial system. And still to this day, there are some systems being monitored by what are called justices of the peace. They can be not even lawyers. It depends on if they're elected, appointed, where they're at. This is a sort of a fleeting, outdated system, but it is something that's still in effect in some areas of the country. And they are going to have a very low caseload, especially compared to a magistrate court judge in a major city. They're going to hear sometimes odd cases, again, just the small things that come up in rural areas that might have to be decided by a formal government official. They are typically under-resourced, relying a lot on public defenders, or also on contract lawyers, or it's the requirement in some rural areas that lawyers take indigent cases. One of the hallmarks of these proceedings is that they're in small towns where it's frequent that people know one another. So that can be a good or a bad thing depending on your perspective on a particular case. But it is something that sort of has to be taken into consideration, the sometimes over familiarity of the justices of the peace with the people that they are deciding cases about. Now, They're supposed to be impartial, and some are probably better than others about doing that. It's just one of those things that sort of is a factor of the um, not always fair nature of the criminal justice system. Um, Again, the courts of limited jurisdiction in major metropolitan areas are often called municipal courts. They hear a lot of cases. Um, they hear, potentially over 100 cases a day, sometimes multiple times a week, sometimes even more than that. It just depends on what the individual needs of an area are. They can hear lots and lots of cases, and some judges are more efficient at clearing those cases than others. It is seen as a very routine process. Again, a lot of the offenders are processed by the system 5, 10 times a year, getting arrested for minor offenses, spending a couple days in jail, and being released. So a lot of times they know the system. So it's a very kind of a meat grinder like system where um, they're not doing anything to stop what's happening. They're just getting better at processing it. Some of the issues with the lower level courts: inadequate financing, inadequate facilities. Again, that's what sort of prevents some of the justice of the peace areas from evolving into a municipal type court, is not having these things to even meet that standard. Sometimes they can have lax courtroom procedure, which can create issues for appeals. If something is done that shouldn't have been done, or something should have been done and wasn't done, someone was allowed to be on a jury, or evidence was allowed to be heard. There's a lot of things that can come up when the rules of procedure are not followed as they should be in some cases. Um, the the type of courts that many people feel they're the most familiar with, because they've seen it so many times in news stories or in fictitious accounts of courtrooms, are trial courts of general jurisdiction. They could be called state courts. They can be county courts. There's a variety of different names. Superior Court. It really just depends on where you're at. There's a chart in the text that describes just the different names that courts have for different types of courts. They're typically based on a geographical boundary, whether that's a city, a county, or this entire state itself. These are the cases, the courts are going to hear the majority of the sort of street level felonies, the cases that actually do go to trial. A lot of them get handled and pled out at a lower level, but the cases that go to trial are going to be heard in the courts of general jurisdiction. Following a case being processed through the court of general jurisdiction, if one side or the other does not like the outcome, they can file an appeal. That's done in the Intermediate Court of Appeal. Again, a lot of different terminology for exactly what it's called. The main reason that it is formed in a lot of areas is the same with the federal system, to take pressure off the court of last resort, to take pressure off the Supreme Court in the federal system. So they can hear the cases. Again, you have to appeal a case based on a matter of law, not a matter of fact. You can't appeal that you were innocent. You have to appeal based on some procedural or other issue that occurred at the trial. Matters of fact are decided by juries. Following a trip through the intermediate level of appeals is the state high court of last resort, state Supreme Court is what it's called in Georgia. It just depends on, again, what state to state, what they're actually going to call it. It's the highest level state court. They do constitutionality checks, reviews of death penalty cases in states that still sentence people to capital punishment. They do some of the tasks they do are assigned by law, and some just sort of work their way to them based on the trip through the court system. Oftentimes, before a case is allowed to be heard at a federal court, a state level case, it has to be heard at the state court of last resort, whatever that is in that particular area. So one of those modernization things that I talked about before is because of the ambiguity of the terminology, the names, what systems are in place. Is it a justice of the peace? Is it a municipal court? Is it a court of limited jurisdiction? A lot of the push for reform in the court system in the United States have been directed at what's known as court unification, basically simplifying the structure of the system to make it more understandable, comprehensible for the lay person who is likely to be processed by the court. There is a chart in the text looking at Florida's system where there's very clear levels: the lower level, the general level, the appellate level, and the Supreme Court level. And it does really streamline the process. And anytime in government systems where you can remove unnecessary bureaucracy, you're probably going to help yourself out in terms of effectiveness and efficiency with time and money, which are very important. They shouldn't necessarily be driving factors in a court system. We should take as long as necessary to process a problem, but unfortunately, they are realistic factors that have to be considered when looking at how to manage and operate a court system. There's also been a recent innovation in trying to have specialized courts, sort of along the lines of courts of limited jurisdiction. The most common one that you'll see is drug courts. They've also tried to group some other types of cases together, domestic violence courts, to be able to break down the nuance in those cases. And is this an issue of serial predatory victimization? Is this common couples violence? There's a lot of types of domestic violence that goes on, and it's very important to address the different types with particular targeted responses. We've also seen the development of mental health courts, trying to divert people that that do suffer from mental illness from the larger system, with the intent of them getting some sort of medical help, as opposed to just being processed by the fairly unforgiving criminal justice system. There is debate in some areas about what these things are. So drug courts, for example, there are two kinds of drug courts. One of them is effective towards reducing the net harm done by drug offenders, and the other one is kind of cop-out political garbage. The first type it will talk about is the cop-out political garbage, which is the type of drug court that's implemented, for instance, in Cobb County. We're lucky to have local types of these courts here. This is aimed at targeting first-time offenders, and then basically making them go through a drug treatment program, which they may or may not need. They may or may not be problematic users or addicts. And if they can successfully complete the process, they basically allow them to remove the charge from their record, which is something that would happen anyway in the state of Georgia with our first offender laws. So they're not really effective in reducing a lot of harm. They're not really targeting very problematic offenders. The other type, which has been implemented in DeKalb County, seeks to identify drug-based offenders that have between 10 to 12 previous arrests and very, very limited violent history. So people that are nonviolent, but that are getting arrested a lot and using a lot of the system resources in terms of police interaction, courts interaction, correctional interactions, to try to get the most net benefit from one offender. And this program often takes 12, 18, 24 months, depending on the needs of the individual. They try to tailor the process as much as they can to the individual, and really work at reducing a lot of expenditures and harm on society and the system. You know, if you get a kid in Cobb County that, I mean, odds are, even if you have a first drug offense, you might have more, maybe. You might not. There's a good chance that you probably won't, that you just have the one interaction. On the other hand, if you're looking at the people that are being serviced in DeKalb County, these are individuals that are going to continue to interact with the criminal justice system if we don't do anything to stop that from happening. So those types of drug courts work to target those high risk, high reoffending offenders, and get the most out of the resources that we put into them. It's often difficult for some people that are studying the system to understand that the areas that can be best served are the ones that are the most impoverished, the ones that are the most crime ridden, the most net positive to society can be achieved by directing resources at people that are, in the case of drug addiction, the most far begotten. Um, okay, so that's the review of the state courts. Remember to maybe go back and look at the federal court lecture now, having watched the documentary about the Supreme Court, and sort of just refresh your brain about some of the important operations of those courts and what that sort of looked like in practice over the course of the judicial career of Justice Ginsburg.